Good morning. Thanks so much for joining us. It is 10 o'clock Eastern. I'm Ana Cabrera reporting from New York, and we begin with new skepticism from a judge in Georgia that Donald Trump and his 18 co-defendants can be tried together next month. Now, the Fulton County District Attorney's Office revealing that they expect this trial to last 4 months with some 150 witnesses. And they're still eyeing an October 23rd start date to try all 19. Here was Judge Scott McAfee's reaction during a televised hearing that played out in Georgia.
It just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction.
The judge also denied a request from Kenneth Chesebro and Sidney Powell to sever their cases. Our legal analyst Joyce Vance and Charles Coleman are standing by. But first, let's go right to NBC's Katie Phang, who was in the courtroom and is joining us now from Atlanta. Katie, March was the original start date proposed by the district attorney, but that bumped up to October when Chesebro and Powell asked for a speedy trial. So as of now, does this October 23rd trial start still stand?
Oh, absolutely, Anna, because under Georgia state law, when a demand for speedy trial is made by a criminal defendant, it has to be honored by the court. There's a very tight window of time within which the trial can commence. And let me be clear, trial commencing means we bring the jury in, we go through the process of jury selection. It isn't just let me set the date and maybe get to it later on. The real challenge for Scott McAfee is going to be the balance of those defendants. Let's be clear. It's not going to take a lot of tea leaf reading to say you're not going to see all 19 defendants, Anna, going to trial on October 23rd. It's let's get the Kenneth Chesebro, Sidney Powell trial started, but what do you do with the remaining 17? And the concerns you heard and that you played for your audience during that clip from yesterday's hearing was he only has 40, maybe 40-something days to be able to handle multiple motions, pre-trial motions, substantive motions to suppress that we know are going to be filed. This case was brought through an indictment from a grand jury, Anna, and so because of that, there's a lot more complications versus just a street arrest, for example, with law enforcement. And so because of all the different moving parts in this instance, Judge McAfee telling the state by next Tuesday, please brief and file what you think it's going to take to be able to handle a 19-defendant trial, considering a number of legal issues that the state did not address yesterday during that hearing.
Okay, so next Tuesday is when we can expect, at the very least, some more movement, potentially, at least more information. Katie Phang, thank you for that update. Joyce, the prosecution estimates a trial for all 19 defendants would take 4 months with at least 150 witnesses. What's your reaction to learning this and the judge calling it a bit unrealistic?
Well, to Katie's point, the judge is simply assessing the playing field here and realizing that with all of these different defendants, each of them asserting different kinds of claims and pretrial motions, it's not realistic to start trial with all 19 of them by October 23rd. But as Katie points out, those who make speedy trial demands must go to trial on this expedited schedule. Otherwise, under Georgia law, the cases against them would be dismissed. So we can expect to see this bifurcated system. And insofar as the estimates about trial time goes, prosecutors are really good at doing this. They know what evidence they have to put on in their case. This is a complicated indictment with lots of moving parts, so it seems realistic. But as far as the 150 witnesses go, it's important to understand that not all of them will be substantive. Some of them will be witnesses who are the government is required to include for technical legal reasons, to show the chain of custody on evidence, or to introduce the sorts of information that might have been obtained by the grand jury. And so although it's likely that if the government says it has 150 witnesses, they in fact do, they will be of varying lengths and different importance as the trial plays out.
We were all able to be flies in that courtroom, Charles, on the wall, because it was televised yesterday. What was your takeaway from what we saw, and what are you watching for next?
Well, Anna, I think one of the things that people have to understand is that there's a certain thing called prosecutorial initiative. And what that basically refers to is that when you are a prosecutor and you're going forward with a case, it's your job to make sure that you answer ready every time that case comes up. And what I mean by answer ready is that you're saying, look, we're ready to go to trial. We're ready to move this thing forward. And so Fani Willis and defense attorneys right now are engaged in a little bit of a battle, basically playing chicken with one another. And it's who blinks first, because Chesborough and Powell have put in these speedy trial motions, it's now on Fani Willis. They're essentially calling her bluff. What people need to understand is that as a prosecutor, Fani Willis has prepared for this, and she understands that there are going to be multiple adjustments and maneuvers that she's going to have to make as counter moves to what it is that they make. So please believe that she does have a backup plan, and she is ready to make the appropriate adjustments that are necessary in order to try some of these defendants who have put in their speedy trial motions while others have not. So this is not necessarily something that's going to catch her on her heels. She understands what the law says about needing to be ready to go forward, and she's going to be prepared to do that.
Just on the timeline, I'll note that there's another RICO case happening in that same courthouse right now, and it's taken 7 months just for jury selection. So mark that in your mind for now. Charles, DA Fani Willis also asked the judge here to keep future jurors' names secret because of the potential for harassment, even threats like she herself has received. How important could that be for seating a fair and impartial jury?
It is going to be a very big deal. I think that when you talk about a case like this, any case that's going to go on for as long as this is going to be a very difficult jury selection just to start with, because you're talking about people who are going to have to take off time from work, take time away from their families, and be in this space where they can focus on the evidence that's being presented to them. That in and of itself is a challenge. Very few people actually enjoy the civic responsibility of jury duty. So getting past that hurdle is already one thing. When you're talking about a case such as this, an unprecedented prosecution of a former president of the United States of America, that ups the level to an unbelievable degree. So the jurors' safety and security is going to be of paramount importance to the judge, to the court, and to ensuring a fair and impartial trial to all of the 19 defendants, which they are entitled to by law, without prejudicing the prosecution from what it is that they seek to do. So I expect a lot of attention to be paid to the jury selection process. That's another thing that I was thinking about as I watched the proceedings yesterday, just the idea that there were so many different things that had to go into selecting a jury. This is not going to be easy, and it will happen with painstaking detail in terms of the different precautions that are taken to make sure that you get a fair and impartial jury.
And so, Joyce, I wonder, does that mean that the jury selection wouldn't be on camera, or how would that work?
So what Fani Willis has asked for is that the jurors' video not be included of them so that they can be identified. But in a situation like this where there are good reasons to protect the jury, it would be possible for the judge to impanel an anonymous jury in this case. Instead of being identified by name, they would be referred to only by number throughout the process, although the parties would know their identities so that they could engage in voir dire. But every possible step would be taken to ensure that they were anonymous, that jury selection itself was only limited viewing.
Gotcha. So let's take a listen to what Donald Trump had to say.
So if you have to go to trial, will you testify in your own defense?
Oh, yes, absolutely.
You'll take the stand.
That I look forward to.
Joyce, he didn't specify which trial, but Trump saying he would absolutely testify. Is that a good idea?
He will absolutely not testify because it would virtually be malpractice for any of his lawyers to permit him to take the witness stand and testify under oath. He would expose himself to additional charges, most certainly. And of course, Trump has a track record of saying that he intends to testify and then failing to do so. I think we can expect to see that trend continue here.
Charles, there was an interesting development in Colorado yesterday. 6 voters filing suit to remove Trump from that state's 2024 ballot. And they point to Section 3 of the 14th Amendment of the Constitution, which states that no person shall hold any office if they engaged in insurrection or rebellion. And I should note that these are 4 Republicans and 2 unaffiliated voters who are suing. Charles, do you see that going anywhere?
Honestly, I don't at this point. I really do think that people have to understand what Donald Trump has been charged with and what he hasn't been charged with. Without substantive legal charges against him at the federal or even state level, to think about Donald Trump being charged with insurrection or charged with seditious conspiracy or charged with any of the other things that we've seen some of the January 6th defendants, for example, charged with, they're going to have a difficult case making that out and establishing that. And I think that's the biggest hurdle. So unfortunately, it may be that this is where that argument dies upon a ruling. However, if there is a judge that's willing to consider that evidence and willing to find that insurrection was something that Donald Trump participated in from a legal perspective without federal charges against him from the Department of Justice and Jack Smith, then that may have some legs and you may see similar suits sprout in different jurisdictions. But as of right now, because he has not been formally charged with it at a federal level, I suspect that this is going nowhere fast.